SJC-10988, Commonwealth versus Parker.
Mr. Fallon, good morning.
Good morning, Your Honors. Richard J. Fallon for Defendant Appellant Harold Parker. In this argument, I want to focus on the factual misrepresentation of the prosecutor in his closing about the blood. A factual mistake I don't think he was even aware of, because there were 31 days of trial. Testimony about the blood had occurred 13 and 9 days before his closing. I have to admit, it took me a really hard time to finally get to the facts of the thing, and I was able to go over and over the transcript. The prosecutor had argued that there were 3 spatter drops of the victim's blood on my client's sweatshirt, such that this revealed the, quote, ultimate lie, end quote, by Mr. Parker, namely that he was 20 feet away opposing the decision. But it turns out that of the 3 drops identified on that shirt, only 2 were determined to be human, and only 1 was tested for DNA. And that test on the Commonwealth evidence was that it's a mixture. It was a mixture with the major profile being the victim, and the minor profile are profiles not known. The important points are only 1 drop on the left sleeve tested, and it was a mixture. The prosecutor argued that the 3 drops probably came from the nunchucks wielded by Luis Vasquez hitting the victim.
What was the distance between the 3 drops of blood?
1 was on the chest, one tested for DNA was on the left sleeve, and the other one was on the left sleeve, and I don't know where, but I think they weren't too far away.
Okay, so would you...
2 in the sleeve, 1 on the chest.
Okay.
The other one on the sleeve was not tested. It was
Right.
very small. That was the one that was
But,
tested.
I guess what I'm asking you is, if we look at the 2 drops that were on the sleeve, and the one that was tested was on the sleeve as well, right?
Right.
So you would have no problem if the prosecutor said there were 3 blood drops on the defendant, and 1 of them at least was, right? Isn't it a reasonable inference that the 2 that are close together came from the same source?
Right, but the whole point is, if the jury had been told it was a DNA mixture, that's what's so fascinating.
So are you it's the mixture is your quibble?
Well, it's both, because only he's saying 3 drops. He's saying 3 drops of the victim's blood, and the Commonwealth brief keeps saying the victim's blood. The DNA mixture is key, because just think, if the prosecutor had said, yes, there was drops of blood, and it was a DNA mixture.
So if the prosecutor said 3 drops of blood,
3 drops of the victim's
3
blood.
drops of the victim's blood, the predominant DNA being the victim.
Yes, but if it's a DNA mixture, how does that come from the nunchucks hitting the victim? I mean, the jury, and there's other evidence, the key point.
But there's no evidence that he's the stabber, so the fact that there's a mixture would support the idea that he's in proximity to the killing, wouldn't it?
No, Your
Because
Honor,
somebody
because-
else may be bleeding from the stabbing.
There you go. Exactly. The evidence was Lauren Elaine, who was identified as his girlfriend, after the stabbing, there was testimony that she brought the knife and handed it to Mr. Parker. And that they handed it over, and that there was evidence, as you just mentioned, that she had a cut on her finger.
That's in the light most favorable to you.
What's that?
That's in the light most favorable to you. There's also the light most favorable to the Commonwealth, which is that he's close enough to where they're stabbing the victim that it sprayed on him, right?
Your Honor, number one, this isn't a sufficiency argument, number one. But the point is, it presents a completely opposite picture if you say a DNA mixture, because the jury's thinking, well, it's not that he was really close at the time. You know, obviously the prosecutor's arguing, Yeah, these 3 drops, he's saying, and it's intent, because of course, his testimony is, oh, I didn't do it, or I wasn't, I held back and they punished me. The prosecutor say, you don't have to listen to the testimony because look at these 3 drops of the victim blood. And no more than, but,
Can I get you to clarify something for me?
sure.
When you said mixture, was it, there's a mixture of DNA, the victim is the predominant, and there's insufficient quantity to find out, or is it there's a mixture and we can't identify the person, or is there an insufficiency of the minor profile? Is what I'm asking.
That's, I'm sorry, I should be able to give you that answer, and I don't.
We'll find
It was
it.
minor
We'll-
profile or profiles.
We'll find it in the record, that's fine.
Yeah, and I think it might be they just didn't have it. I'm sorry.
No, we'll find that.
But the key thing is, common sense, you're gonna look to, oh, a mixture, that's probably when it happened, when she handed, because her cut finger, that's probably when
But
it
isn't
happened.
that just the evidence that works best for your client? I mean, that doesn't have to be the way.
You tell me. I ask you.
That's what I'm telling you.
A mixture. No, but a mixture. You're not gonna say, the prosecutor as a whole said, oh, 3 drops of the victim's blood from the nunchucks. Is anybody gonna think a mixture came from this Vasquez hitting nunchucks? No, that's not gonna be a mixture. That's gonna be her DNA. And in fact, think if the evidence had been it wasn't a mixture.
Really? Why is that the case? If someone's hitting someone with nunchucks, and they could cut themselves while they're doing this, couldn't they? I mean, the person's resisting. But can I ask? Can I put
gonna
this?
say that's
Can I put this?
speculation, but
Can I
ask.
put this in context? So, evidence in addition to the blood spatter evidence, right? We've got the defendant told White and Elaine that they were going to get the victim. That when they heard the phrase "green light," they were to pull the victim down and hold her while Davenport stabbed her. The defendant told Allen to put her knees on the victim's shoulders as Davenport stabbed her. The defendant told Allen to put a bandana on her hand so that if the victim tried to bite her, it would not hurt. Afterwards, the co-defendants, White and Allen, drove to Harvard Square with the defendant, where they kidnapped one of the gang members, Assad. They took him to a park where they sat him down, showed him knives and the nunchucks. This goes on and on. There's a lot here besides the blood. The blood may finish it up, but you need to show that he's somehow separated himself given all this other conduct, right?
2 reasons why, yes, you're right, but 2 reasons why the blood is so key. Number 1, the prosecutor, the focus is the prosecutor, because my client was one, let's face it, Davenport is the guy who stabbed and admits it and is trying to get a pity acquittal. And Luis Vasquez and the brothers Vasquez were in the front of the seat. We know they're the heads of everything. My client is the only one there, and of course it's not, he's very cocky and arrogant, as they say, but he's the one person that's something he says, hey, I wasn't involved. And in fact,
What?
there's a lot, I wasn't involved. I protested against it. But here's the thing, Your Honor, because they might not believe.
He protested against it, but it's blood in and blood out throughout this incident.
But
and,
you
and
could,
he's still very much in, and there's not his blood out. He's very much part of this whole thing as it's going on. You have to deal with all of that in addition to this 3 spatters of blood versus 1 spatter of blood.
But look at the focus of the prosecutor's argument first. He knew Mr. Shapiro's argument kept saying, you can't believe these people. They're the ones who actually did it. And page 13, 14 of that transcript, 31, he says that. So the prosecutor counters this by saying, you don't have to believe 1 word of Lauren Elaine and Anna White, because he knows their credibility is terrible. So that really counteracts. That's why the blood is so important, and that's why the prosecutor is focusing. You don't have to believe 1 word. And the other point, sure, there's that evidence, and in fact, the prosecutor argument, and then you could argue that's the Commonwealth's best argument here. Say, look, afterwards, there's good evidence that he kidnapped somebody. But remember what happened after they kidnapped this person named Assad in Harvard Square. The Vasquez brothers and the evidence is my client, bring him to park, beat him up, threaten him, and then on the drive back, they say, hey, we have a new gang, the Assassins, and you can be part of it, just kill somebody for us. But the evidence is these fellows are desperate for anybody, and that it doesn't matter if somebody's betrayed. They saw this fellow, Assad, whose nickname was Chaos. He betrayed them, but then the next moment they're beating him up, and the next moment say, hey, you'd be part of your gang. So that evidence of the kidnapping can go both ways. A lot of evidence here can go both ways.
But if it goes both ways, it's not good for you if it goes both ways, right?
No, it is, Your Honor, because
Isn't it really difficult to try to ascribe rational conduct to this group of people, given what they did?
that's an understatement, but
Yeah.
what's your point?
No, the point being that when you're saying something doesn't make sense, none of this makes sense.
Yeah, no, I'll agree with
A
you.
horrible case. I
but-
mean, they all are, but this is particularly disturbing.
Right, no, it is, it's horrible, there's no other way to
But-
put it.
So I guess it cuts against your argument. Well, this couldn't have happened because it wasn't logical. None of this is logical.
No, but that doesn't cut against me, because the point is, for example, the point is that the Commonwealth, another place it goes both ways. The Commonwealth's argument, and it's reasonable, says, look, this was my fellow, and I agree, was a seconder all the time. He was a lieutenant. He'd always say, yes, sir. And this was exactly what they said they would do. If you go against us, we'll kill somebody close to you. This fellow Bamford went against them, and the victim Bamford was protector / boyfriend of the victim, and so you can interpret that way. That's reasonable. But on the other hand, Mr. Shapiro, Parker's attorney, brought out that really there's a lot of evidence the impetus was Anna White, because the poor victim, we don't know if it's serious, but surely Anna White took it serious, was made Queen One up at the apartment in Lowell, and she was going to become the companion, apparently, of Luis Vasquez, who wasn't wedded to anybody. And Anna White, the testimony from Lauren, got really, really angry and came up with this cockamamie idea that the victim's dream meant she knew ahead of time, and in the car ride back to Cambridge, kept harassing her boyfriend and saying, look at this dream, she knew, until the poor victim tried to get out of the car and was pulled in. And you can sort of sense that was the end. That was the time when they decided. But there is plausibility to my client refusing, because, and I'm sorry, it's in my brief, but I don't have the citation. He was said, Anna White at volume 16, page 231, said he was always friendly. He was always friendly with her.
But it's contradicted by the fact that he's giving direction to this. If he's against the killing, why is he sort of helping to orchestrate it and direct it?
If you believe Anna White and Lauren Lane, which the whole point is the prosecutor said, you don't have to believe one word of their testimony. And that's why this error is so, I'm sorry, I haven't made it clear. Let me just say that.
Well, you say, error. It's not error that there was blood on his sleeve. It's not error that it's not error that that her blood was found on the sleeve. You're saying it's error that he failed to say that it was a major profile and there was a minor profile of somebody else. Is that your view of prosecutive error?
Yes, I like my analogy of back in the 50s, we would say Edmund Hillary was the first person on Mount Everest. No climber now would say Edmund Hillary was the first person to climb Mount Everest.
But you
They'd
have,
say,
I mean.
you know what I'm saying?
This
Half-truth can
was,
be as
speaking of Hillary, and in, I think Torvalds, was it?
Norgate.
You sort of have the Hall of Fame of defense lawyers in this case. You've got Shapiro, you've got Weinstein, you've got Doolin. Did Shapiro make any argument focusing on the minor profile as supporting his view that he was 20 feet away? Was that ever made in his part of his
No,
closing?
and he you're right. He did an excellent job on pointing out that there was also a personal interest, which makes it more likely. And the whole point of my more likely is, no, he said, well, maybe the blood. He didn't do that. He was focusing on it might not have been my client's sweatshirt, and that you can't trust these people's testimony. But Your Honor, 4 times, and here's where I have to point this out before I forget. 4 times, I'm sorry, my brief, I beg your pardon, my brief was inadequate, because I said there were 2 times when the prosecutor mentioned, the 20 feet away, and there are actually 4 times. And in my main brief, it only did twice. Let me very, very quickly give you the 4 places. Because at page 107, this is all in transcript volume 31, I'll quote, this is the prosecutor's closing quote, and Harold Parker wants you to believe he pulled himself back, that he opposed the decision to kill the victim. And then at page 110, 111, that's where he says, you also heard about the, quote, you also heard about the 3 spots of spatter on his shirt. But he told you he was 20 feet away while the murder was being committed. He told Trooper Antoine that, 20 feet away, end quote. And then she goes, then he goes, from the testimony, non-checks and says, that's probably how these 3 drops of blood get there. And then at page 118, quote, and what is his ultimate lie? He's 20 feet away. And then at page 123, that's where the prosecutor's ridiculing all the defense attorney's point. Mr. Doolin wants you to believe the alibi witness is credible. And then I'll quote, Mr. Shapiro wants you to believe that Harold Parker stood 20 feet away opposing the decision. You all know that's not true, and all know that doesn't make sense, end quote. But his whole basis that he was closer than 20 feet, therefore, and it's all about a 10. We realize it's all about a 10 for Mr. Parker, that he's lying.
Let me ask you just another DNA question. Was this a cut-in from the sweatshirt?
I believe so, Your Honor. I believe so. I think they were all, yeah, I'm almost certain. I'll defer if I'm wrong, but I think they were all, all pieces were cut.
And are you the expert said that was blood spatter on the sleeve?
Yes, but you could get blood spatter from a drop of, I'm not contesting any of that, Your Honor.
Well, it seems you are, because you're saying it can't be blood spatter, it has to be transfer.
Well, blood spatter as she's transferring, if there's blood on a knife and I'm transferring it to somebody, it surely can spatter on their sleeve. In fact, it would make sense it would spatter on their sleeve. Your Honor.
Wouldn't a cut-in from a sweatshirt naturally have the DNA of the person who wore the sweatshirt?
I'm sorry?
Wouldn't a cut-in from a sweatshirt naturally have the DNA of the person who
Yeah,
wore
but
the
they said
sweatshirt?
the blood, I believe they said the blood had a mixture, that the spot of blood, in other words, it's identified as a spot of blood. And it also said unknown profile, minor profile. They did know the profile, I believe, of my client.
Right.
I know my time's getting close. There's just a couple of things I do want to say. One is, and just on the suppression, just because it's another mistake by myself, I believe now on the suppression issue of the search, I believe now I was wrong in claiming that inevitability exception doesn't apply at all here. I think I misread the Parrott case. I think inevitably applies if virtually certain that evidence subsequently would have been obtained lawfully other than by search warrant. I think that's what O'Connor says. However, the key point is, that I don't think I stressed enough in my brief, that when inevitability is measured or determined is on the circumstances existing at the time of the unlawful seizure. And that's O'Connor at footnote 4. And so on that, I just want to say I don't think it was neither exigent or inevitable, because they didn't know if the fellow was going to get out or not. They didn't know if he was going to get... Now, also, I really want to say, and maybe this is the last thing, and it's not in my brief, but Anna White, in question of cross-examination, said, yeah, that Mr. Parker was far away from the place where she was involved in killing the fellow. And that's at volume 16 at 229. So this whole claim that he was closer than 20 feet was even against his own witness. But just the fact that he made that claim on the blood and said, you don't have to listen, you don't have to believe a word of those people. It's the blood. And half-truths can be as, and in this case can be as misleading as not saying the truth. Again, I just want to, and this will be my last, just want to focus on two scenarios I believe you should think about. One, what if it really had been just her blood? The blood, not a minor profile, not a DNA mixture. Great evidence, marvelous evidence. No wonder he would have, that's exactly what you want. That would have been great. And that's what the prosecutor argued on, but that wasn't the truth. Flip it around. What if the prosecutor had said, it was a DNA mixture? What if he told the jury, DNA mixture? They're not going to be thinking that it came from nunchucks. They're going to be thinking it must have come from the switch on the knife. Now, and this will be the last thing I say. You might say, and the Commonwealth would say, hey, that's still, where does that get you? Because that's still legally, he could be guilty of murder. We know that's, you don't, even on that, I said it's more like after the fact. Legally, but would they have convicted him of murder if they thought, think of the reasonable juror. He's in the jury saying, okay, let's listen to the prosecutor. Let's just forget about the witnesses. Let's just look at the DNA, the blood. It's a mixture. Where did the mixture arrive from? Well, it probably arose from after the thing, handing over from Lauren Lane, who got a cut on her finger. Are we going to convict of a murder on that? Legally, they could, but, very quickly, I had a case several years ago on appellate where there were 5 people similar. It was a joint venture. They would kick somebody to death, and one of the defendants, not my client, just held the coat. We all know that legally, he could be convicted of murder. We won't be surprised that he wasn't. And that's the substantial risk right there. The difference between, sure, he was right there and he's lying about being further than 20 feet away, and yeah, maybe he wasn't even there. If you don't have any further questions, I'll sit down.
Thank you, Mr. Fallon. Ms. Sachse? Good morning.
Good morning, and may it please the court, Helle Sachse on behalf of the Commonwealth. With me this morning is Assistant District Attorney Patrick Hagan, who was the trial prosecutor, and I would also like to acknowledge the presence of Assistant Attorney General Dean Mazzoni, who was the second trial prosecutor, and former ADA Zach Hillman, who handled the direct appeal and the motion for new trial in this case. Excuse me. The Commonwealth is asking...
Another all-star cast.
The Commonwealth is respectfully asking this court to affirm the defendant's conviction for premeditated murder in the first degree, kidnapping, and to affirm the denial of the motions for new trial and post-conviction discovery. The Commonwealth case here of the defendant's guilt as a joint venture was overwhelming, similar to that of Ismael Vasquez that this court has already affirmed in Commonwealth v. Vasquez for 62 Mass 827 in 2012.
Can you help us out with the DNA testimony? It depends, I guess, on the era of these trials. How detailed was the testimony regarding the extraction of the DNA on the sweatshirt?
I can tell you that it was a cutting, and that this particular stain had been identified as human blood and was then further, and had been identified as a spatter stain. I think that would be important too. And then further DNA testing was done that revealed a mixture, as my brother points out, with a one profile that could be identified, which was the victims with a very high statistical likelihood. The blood evidence in this case on the defendant's sweatshirt only plays a role in
I'm sorry,
the defendant.
you didn't discuss the minor profile. What was said about the minor profile?
Oh, I'm sorry. I would have to go back and check the record. Your Honor, the reason I did not focus on that particularly is because it plays absolutely no role in the overall context of this case.
Why is that?
That is because the defendant was convicted as a joint venturer on a theory that he was 20 feet away from the killing. My brother's argument works only if this court buys into a completely distorted theory of the Commonwealth case, which is nowhere to be found in the closing argument. And I would encourage the court to read that closing argument in its entirety and not just focus on pages 111 and 110 that my brother relies upon. The prosecutor here pointed out, and he never wavered, that this killing was committed by 4 people, or 6 people in total. Anna White and Lauren Elaine held the victim down. Scott Davenport stabbed her repeatedly with a 10-inch knife, and Luis Vasquez wielded nunchucks to silence the victim and hit her 4 times, while Ismael Vasquez was standing so far away that no blood evidence was found on him, and Harold Parker was standing at his own account 20 feet away. And the prosecutor said you wouldn't even expect to find blood evidence on him. And it turns out that there was a spatter stain, or there were 2 identified spatter stains found on his sweatshirt, and the prosecutor's theory was that it was a cast-off from the swinging nunchucks. There's no indication that the prosecutor tried to argue that Harold Parker was wielding a weapon, that he was in any way closer to the killing. And his closing argument is a response to Attorney Shapiro's skillful argument, which presented the fact that the defendant, yes, had admitted that he was 20 feet away, that he was at the scene of the crime, but A, there was no evidence that, or there was a weak chain of custody that this sweatshirt was even his, and that any blood on it would be a transfer stain. That was Attorney Shapiro's argument, to which the Commonwealth, the prosecutor responded, yeah, you would expect not to find blood evidence on this sweatshirt, but it turns out that there were spatter stains, not transfer stains, and that these came as a result of the swinging, the nunchucks that were swung and blood flying through.
Was there expert testimony regarding the difference between transfer and spatter stains?
Yes, there was. Mr. Cumulus Pratt testified to at great length about that. There was a motion for a Dober hearing on that evidence, and that was all litigated in the Vasquez case. Attorney Shapiro had filed that motion. All the other defendants joined in on it, and Judge Brady denied it, ruled that evidence of spatter stain evidence was sufficiently reliable before and after this case.
Just one, and I should know this, but I don't. Your brother sort of suggests that transferring the knife could result in spatter, in the sense you're passing the knife along and blood would shoot off of it. Is that consistent with what spatter is?
It could be, of course, depending on the force with which an item is thrown, the distance. And here, these defendants all crowded into a Mitsubishi Galant after the killing. There was blood found on Harold Parker's pants, which I believe was identified as transfer stains. So the bloody knife was found in the car when the defendants were stopped in Cambridge shortly after the crime. There was blood evidence all over the place. And the few droplets of blood on this sweatshirt, which arguably was the defendant's, play absolutely no role in the overall context of this case.
Well, it was argued. I mean, you can't
course
say
it
what,
was
I
argued.
mean, the ADA argued it, that you don't need to listen to the witnesses, the blood speaks for itself.
The blood, but not just the blood on Harold Parker. The blood on the knife, the blood on the nunchucks, the blood on Lauren Elaine, Anna White, Scott Davenport, and Luis Vasquez.
And how, but he argued that the blood on Mr. Parker came from the nunchucks, I gather, or likely came.
That is the
spatter.
overall gist, yes,
Okay,
because it
and
was
so
spatter.
your brother says, how can that be if there's a minor profile?
It can be because this was on the defendant's, on the sweatshirt sleeve. He was wearing that sweatshirt. He could have wiped his nose before he was hit with a blood stain, and that could create a mixture.
Okay, what was the minor profile? Was anybody eliminated as sources of the minor profile?
I
I
believe
sort of
it was,
recall there was something about that in the,
insufficient.
sorry?
I believe it was insufficient to create a profile.
So there was someone else, but we don't know.
We don't
There's
know.
insufficient quantity.
Correct.
And I assume that they had compared they had taken his DNA as well, Mr. Parker's. When they lined up the comparisons, I assume the victim was involved and the defendant, or some of the
I
defendants.
believe so. I would have to double check that, Your Honor.
Even if this was error, would it be harmless?
Absolutely.
And why?
Because the evidence of the defendant's guilt as a joint venture was overwhelming. He's the one who announced the plan to kill the victim to Anna White and Lauren Elaine. He instructed them on the roles they would take. He told them that Scott Davenport would be stabbing the victim. He gave a bandana to Lauren Elaine to wrap around her hand so that she would not leave any fingerprints and would not be bitten by the victim. He remained at a distance of about 20 feet, saying someone at his level doesn't have to do any dirt work. Afterwards, after the killing, he asked Lauren Elaine whether she was all right. Then he crowded into a car with all the other defendants. They drove to Harvard Square where they kidnapped Eddie Assad, took him to a park where he received a gang beating and where the defendant then announced the forming of a new gang by the name of the Assassins, and he showed everyone how to form, how to make the gang's sign. And
Was that him or a co-defendant?
I'm sorry?
Was that him or a co-defendant?
The throwing of the gang sign, I believe that was Harold Parker.
Announced the new gang. I thought it was one of the two leaders. Am I mistaken on that?
According to my reading, he was
That was him?
part of that. They were, all three of them were engaged in that. But essentially, through the kidnapping, they continued the same motive that had led to the victim's killing by punishing gang break-offs. And Assad had been one of the individuals in Harvard Square who had learned from members of the Latin Kings that the defendants here were only fake members of the Crips and were indeed Latin Kings. And he began the process of this, I suppose, gang revolt that led to the victim's murder. So they killed the victim, they got into a car and continued their quest of punishing other gang members. That is the evidence against the defendant here.
On the motion for new trial, I'll be honest, my head started spinning on the different bags and strings, et cetera. So you want to take a crack at summarizing why that's not meaningful?
I will do my best, Your Honor. Again, this is only relevant if the court buys into my brother's new theory of the case, that the defendant was somehow directly involved in wielding a weapon against the victim or was closer to her than the 20 feet at which he put himself.
Well, it only matters if the sweatshirt's important.
Well, Attorney Shapiro here skillfully attacked the chain of custody of the sweatshirt at every opportunity. He told the jury that the Commonwealth couldn't even say whether the defendant had been wearing this at booking because his booking photograph showed him wearing a different T-shirt, that criminalist Pratt only took items out of a box and identified them by the label of the box. Attorney Shapiro challenged the sweatshirt. My brother now
All the way
says,
back to court, when the court officer has it for a while and it's not tagged at that point.
Correct.
Yeah, right
Yes.
through that in the cross-examination, as it relates to chain of custody.
Yeah, Attorney Shapiro attacked every single one of these points. My brother now
Okay.
says that this court should focus on a label on the box in which the evidence was placed 2 days later after Sergeant McDougal had picked it up at the Middlesex jail at this point, where it had already been through a booking process, through Trooper Condon's securing of the evidence in the hands of a court officer, gone to the Middlesex jail, put in plastic bags, and then ended up in a box. That's where he claims this evidence should be attacked. And it's miles removed from what was actually relevant. And Attorney Shapiro argued the relevant parts. So this motion respectfully has really no relevance.
But it isn't a, tell me if my memory's incorrect, it isn't a box with Vasquez's name and his name lined out, isn't it?
Correct.
Okay.
These boxes are labeled, they're labeled at the top, and this particular box, Exhibit 120, is labeled, I believe, Luis Vasquez. And on the side, there's a,
But the sweatshirt's not in that one, right? The sweatshirt's in a different one with his name on it, right?
correct.
Right, it's not, there's a box labeled Vasquez with his name crossed out, but the sweatshirt's not in that.
The box, there's another box that's labeled Harold Parker.
Right,
Yes.
where the sweatshirt is.
Correct, yeah. And the jury, in fact, because all the packaging was admitted in evidence as exhibits, the jury had this exhibit. They saw that there was a box that had a crossed-out name on it, and they would have been able to determine whether they believed there was any evidence relating to Harold Parker in that box. As the prosecutor pointed out in his closing argument, the proper chain of custody was supported by the fact that other items, such as this T-shirt the defendant was wearing in a booking photograph that had sort of a dragon pattern on it, was in fact inside the box labeled Harold Parker. And he used that to argue that the chain of custody, even though it can be challenged, is also supported to be intact by items such as that T-shirt. If the court has no further questions, I ask you to affirm the convictions. Thank you.
Thank you.